The OTA case number is 1801-2040, and today's date is Tuesday, September 29th, 2020. The time is approximately 10 a.m., and today's hearing is noticed for Sacramento, California, and is being conducted electronically with the agreement of the parties. Today's panel consists of 3 administrative law judges. My name is Andrew Quee, and I'll be the lead judge. Judge Joshua Aldrich and Judge Keith Long are the other members of this panel. Although all 3 judges will meet after today's hearing and produce a written decision as equal participants. Although the lead judge, that's myself, will conduct the hearing, any judge on this panel may ask any questions necessary or otherwise participate in this proceeding in order to ensure that we have all the information necessary to decide this appeal. For the record, I'd ask that the parties please state their names and who they represent, starting with representatives for CDTFA.
This is Kevin Smith. I'm from CDTFA Legal Department.
This is Andrew Quee. Would the other representatives for CDTFA please state their names for the record?
This is Jason Parker, Chief of Headquarters Operations Bureau.
Monica Silva, representing CDTFA.
Thank you. And again, this is Judge Quee. Would the representatives for the taxpayer please state their names for the record?
Good morning, Your Honors. My name is Eric Tresh. I'm with the law firm of Evershed Sutherland, and I represent T-Mobile Resources in this matter.
Good morning, Your Honors. I am Tim Gustafson. I'm also with Evershed Sutherland, representing appellant T-Mobile Resources Corporation.
I believe the third representative is muted. This is Judge Quee.
My name is Lee Drury. I'm an employee of T-Mobile.
Apologies, I'll try that again if I may.
Yes, please go ahead.
Sorry about that. Good morning. I'm also with Evershed Sutherland representing T-Mobile Resources Corporation today.
Liz Shaw?
Yes, Liz Cha. Apologies.
Okay, this is Judge Quee. Thank you. Was there a 5th person for T-Mobile today, or is that everyone for T-Mobile?
Yeah, good morning. My name is Stefan Xu. I'm an employee at T-Mobile.
Okay, great. Thank you, everyone. I'm just going to briefly go over some procedural matters to make sure that we're all on the same page before we start with the opening presentation. So I understand that there are 2 witnesses, and both of the witnesses will be called to testify and solely for the issue 2 closed session portion, which is whether a refund claim is warranted. And I understand both witnesses are present, which is Lee Drury with T-Mobile and Shifeng Xu, also with T-Mobile. Is that correct?
Yes, Your Honor.
Okay, and for CDTFA, do you have any objections to hearing testimony from these 2 witnesses?
This is Kevin Smith. No, we do not.
Okay, thank you. And as far as the exhibits, I understand CDTFA has exhibits A through C. These exhibits have been distributed to the parties, and appellant has no objections to CDTFA's exhibits. Is that correct, appellant, for the appellant?
It is, Your Honor. No objection.
Okay, thank you. And for appellant, we have appellant's exhibits 1 through 7, and those were also distributed to the parties. And I understand that CDTFA did have an objection to these exhibits. Is that correct for CDTFA?
I don't believe so.
Okay, I'm sorry.
No, I don't think we have an objection.
Okay, so if CDTFA has no objections to the taxpayers' exhibits 1 through 7, then I will go ahead and admit all of the exhibits A through C and 1 through 7 for the parties without objection. Thank you. And so with that said, I also had an item which during our pre-hearing conference I had mentioned that OTA intended to take official notice the BOE minutes of hearing and the BOE public agenda notice, and I did not receive any objections. Is that correct for appellant?
It is correct, Your Honor. No objection.
Okay, and for CDTFA, is that also correct for CDTFA?
This is Kevin Smith. Yes, that's correct.
Okay, thank you. So OTA will be taking official notice of those two items in connection with the first issue, which was the whether or not there's a timely claim for refund. During the pre-hearing conference, I had also notified the parties that OTA was raising the timeliness issue, issue 1, which will be heard during the open session, and both parties were offered an opportunity to provide additional briefing or post-hearing briefing. Does either party know at this point whether they will be requesting an opportunity to provide post-hearing briefing, or if they're satisfied with handling this entirely during the presentations today? I'll start with CDTFA. Are you going to be, or do you know if you're going to be requesting additional time?
This is Kevin Smith. No, we will not be requesting additional time. We think today is sufficient to handle the matter.
Okay. And for appellant, do you know if appellant will be requesting additional time?
Your Honor, this is Eric Tresh. May I reserve the right to inform the Office of Tax Appeals at the conclusion of this hearing whether we'd like to request post-trial briefs, post-hearing briefs?
Yes, certainly. Thank you. I will follow up with the parties at the conclusion of the hearing to find out if we're going to hold the record open at that time. Okay, and just a quick, certainly. And just a quick summary then, there's going to be two issues. Those two issues are, one, whether the refund claim is timely. This issue is going to be addressed during the open session, which is currently being live streamed. Upon the conclusion of the presentation for issue 1, we're going to turn off the live stream and move to a closed session. At that point, we're going to address issue 2, which is whether appellant is entitled to a refund of tax paid. And then this will be held during the, so the balance of the hearing after issue 1 is going to be during a closed session. So basically, we've set out a time frame for issue 1, which was 10 minutes per party for an opening presentation and 5 minutes per party for a closing presentation. For issue 2, apologies. For issue 2, the refund claim, we set up a time frame of 30 minutes per party for an opening presentation, 60 minutes for witness testimony, and 5 minutes per party for closing presentations, with the possibility of slight modifications, reserving time if additional time is needed for witness testimony, pushing over additional time from the opening presentations to allow for additional time during witness testimony. So there is some flexibility here during the presentations. Is this the understanding of both parties?
This is Eric Tresh, Your Honor. Yes, it is.
Okay.
For T-Mobile.
This is Kevin Smith. Yes, it is.
Okay, great. Thank you very much. So before we move on to our opening presentations, would either party like to ask any questions about the process or any questions about this appeal?
No, Your Honor.
No, we have no questions. This is Kevin Smith.
Okay, great. Thank you very much. Then I'm going to turn it over to the representatives for appellant T-Mobile to start with their opening presentations. You have approximately 30 minutes. You may proceed.
This is Tim Gustafson. Thank you very much, Your Honor. With regard to the issue and the question of jurisdiction, just to give you the bottom line up front, that the Office of Tax Appeals has jurisdiction to hear this appeal, and that's pursuant to OTA's Rules for Tax Appeal Section 30103B1. That's a timely appeal from an adverse appeals bureau decision. Now, this adverse decision is the department's decision and recommendation dated October 23rd, 2017. But how did we get here? Well, this adverse decision, this DNR, represented the culmination of the appeal process with the department for a refund claim filed by appellant on July 20th, 2016. Now, the only issue raised in that refund claim is the markup issue presently before this panel. And I'll speak to why this refund claim on the markup issue was both timely and a necessity and necessary in a moment. But some clarification is in order because this question of jurisdiction arises from two prior refund claims regarding a separate issue that were filed by appellant in 2011 and 2014 for a total of $12 million. Now, these prior refund claims cover the period April 2009 through March 2013. So you had one claim for the first couple of years and the second for the last couple of years. And which your honors, and this time frame, which your honors will note, is basically the same periods presently at issue on the markup claim. But the key difference is that these earlier refund claims raised a single issue, and that issue was related to the taxability of electronically delivered software. So we have two refund claims that we're going to be talking about. So for ease of reference, I'll refer to these earlier claims collectively as the software claim, and the claim pending on appeal before your panel as the markup claim. Now, when appellant filed the software claim, the department, formerly the Board of Equalization staff, again, for ease of reference and for the record, I'll just refer to the agency as the department. The department audited appellant's returns for the periods at issue. Now, as a result of that audit, the department recommended granting that software claim in its entirety, but the department also affirmatively raised a markup issue as an adjustment. And kind of considering that adjustment in isolation, that would be a deficiency adjustment. So in this markup issue, this adjustment was valued at approximately $300,000, and the department recommended applying that $300,000 as an offset against the software claim, that $12 million claim. And so this meant that the department ultimately recommended a payment to appellant of about $11.7 million. So at the end of the audit, the department staff has this recommendation, but given the size of the refund that's recommended, the 5-member Board of Equalization had to weigh in on it and had to weigh in on the department staff's recommendation. And that's what brings us to the January 26th, 2016 board meeting. Now, at that meeting, which is what your honors took judicial notice of the minutes in the agenda, the 5-member board considered staff's audit recommendation for appellant's refund. Now that's the software claim, along with all of the other staff recommendation for refunds exceeding $100,000 in a single consent agenda item. So when appellant's refund was brought in this item, it was alongside a whole host of other refund items for separate taxpayers, separate issues, all because of this threshold amount that the board itself had to review. So, for example, if you look at page 8 of the minutes for that meeting, you'll see that there was a single unanimous vote on the entire agenda of staff recommendations. So this is this consent agenda item. And you'll find T-Mobile's appellant's item at the bottom of page 9, right? So you've got 2 pages and plus some that were all considered in this single vote. And I think it's important to note what that board action was not. So this was not the Board of Equalization acting on any appeal related to the software claim, because there was no appeal. The department had just wrapped up its audit. So if you compare that consent item with the item on the bottom of page 2 of the minutes for the January 26, 2016 meeting, there the minutes reflect that there was a sales and use tax appeal hearing in the matter of New NGC Inc. And final action on that appeal was taken later in the meeting on that same day, as reflected on page 17. So what the board did with regard to that taxpayer hearing of an appeal and ruling on acting on that appeal in the sales and use tax case, that's not what they did with regard to appellant. And with what they did with regard to appellant, is that they merely approved the staff's recommendation, their audit recommendation, as it was the board was required to do for a refund over $100,000. And subsequent to the board acting on the approving the staff's recommendation, the department issued a notice of refund to appellant on January 27th, 2016 of approximately $11.7 million. Now, again, this amount reflected the department granting the software claim effectively in full, but taking payment for the markup issue at the same time in the form of an offset. And when the department sent this notice of refund to appellant, it included a cover letter. And this cover letter stated that if appellant disagreed with the offset, it would need to file a refund claim within 6 months. And that's what appellant did. And when appellant did that, the department treated that claim as timely and continues to treat it as timely, and rightly so. And why is that? Well, for our purposes, we're going to turn to some of the statutes and rules that Your Honor identified in the order from the pre-hearing conference. But for our purposes, Revenue and Taxation Code Section 6902 provides that a refund claim must be filed within 6 months from the date a determination becomes filed, or 6 months from the date of overpayment. Now, when the department issued that notice of refund on January 27, 2016, the determination on the audit determination of that markup issue became final. So, and kind of viewing it another way, when the department issued that notice of refund, it effectively collected an involuntary payment from appellant on the markup issue in the form of an offset. And when appellant filed its markup claim on July 20, 2016, that was within 6 months from the date of that notice of refund. To kind of give another parallel is one could look at this even that there may have even been a 3-year statute of limitations to file a refund claim, and that would be under Revenue and Taxation Code Section 6902.3. Now that provides that a refund claim for overpayment of tax that is collected by the department through quote unquote enforcement procedures is timely filed within 3 years of overpayment. Right. So this taking of an offset from money at the time that they were also issuing money on, taking an offset on the markup issue at the time they were issuing a refund, a full refund on the software issue, is again akin to an involuntary payment or something along the lines of these enforcement procedures. But again, when the department mailed appellant that notice of refund, it informed appellant that it had 6 months to file a claim for refund, which appellant did. And now, Your Honors have asked about certain other authorities and whether they apply with regard to the Board of Equalization's action in January 2016. First, former BOE regulation, now CDTFA regulation 5561, governing petition for rehearing. For that regulation to apply, there needs to be an appeal and there needs to be a hearing on that appeal. And here there was neither. Again, this was the board simply approving audit staff recommendation on the software claim. There was, and they granted that claim in its entirety. There was no appeal pending, and there was no hearing like that other sales and use tax appeal for that other taxpayer. So the software claim was just a matter on the board's consent agenda. And turning to Revenue and Taxation Code Section 6933, and which is the basis for a refund action in court, that this statute supports a finding of jurisdiction on the markup claim. And because that statute provides that an action for refund is limited to the grounds stated in the administrative claim. Now, the only grounds stated in the software claim, that's the one that the board acted on as part of the consent agenda in January 2016, was the taxability of electronically delivered software, which the board granted. So the markup issue was not in that software claim. Appellant could not, as a matter of law, bring an action of court on the markup issue at that time. But in fact, in order to preserve its rights to do that, appellant had to file a new refund claim with the department, which it did within 6 months from that notice of refund. So, and if appellant hadn't done that, hadn't filed a new claim with the markup issue stated as grounds for that claim, then it would never be able to pursue an action for refund in court under Section 6933. Lastly, one thing I'd like to note is that something that the department never issued a notice of denial of refund claim to appellant. It only issued a notice of refund. And that's because the department granted appellant's software claim. but took payment from appellant on the markup issue in the form of an offset. And then appellant filed the refund claim, the markup claim, within 6 months of that payment. And I'll reserve any remaining time for response.
Okay, this is Judge Kui. Thank you. And I believe there will be questions, but before we move to questions, I would like to give CDTFA the opportunity to do their opening presentation.
Thank you. Just have a brief statement. With respect to the issue of timeliness, our position is that the Office of Tax Appeals has jurisdiction to hear this appeal. However, as stated previously, the department defers to OTA to determine whether it will accept the appeal as timely, pursuant to OTA's regulations. Thank you.
Okay, this is Judge Kui. I did have a couple questions. I guess I'll start with CDTFA. So in listening to the appellant's arguments, I just had a question to get CDTFA's input or thoughts to address those arguments. And so in Revenue Taxation Code Section 6902, there is that language of the time frame to file a claim for refund. And one of the provisions is with respect to determinations made under Article 2, you have 6 months from the date the determination becomes final. Does CDTFA have a position on whether it issued a determination in this case, whether the refund notice was the determination which would allow for the 6 month period to file a claim for refund?
Opinion about whether that claim for refund or whether granting the claim for refund would also be seen as a final determination. We just believe that taxpayer was told they had 6 months to file the appeal, and they filed it within 6 months, so we believe it was timely.
Okay, thank you. So I'm just curious, because CDTFA's decision had said that the taxpayer was misinformed that they had 6 months to file, and so under CDTFA's interpretation, what is the correct time frame, and what is the authority for the correct time frame? Is it a statute, a regulation, or a policy?
Well, in the regulation, the regulations governing the matters before the board, and we believe in this case, we can't say definitively because of the way that the case went to the board, but we believe it would have been 30 days. But again, we told them 6 months, so that's we think fair that we stick with that 6 months, and it was filed within that 6 months. So.
Okay, this is Judge Kui. So I'm just curious. So is CDTFA's position that the taxpayer could or could not have filed a petition for rehearing after receiving the refund notice on January 28th or thereabouts?
Well, no, we agree with the taxpayer that a petition for rehearing wouldn't have made sense because there was no hearing with the board, which is on the consent calendar due to, public records laws. So petition for rehearing wouldn't have made sense.
Okay, and just so I'm understanding, is the refund already been paid, or is that still pending an appeal?
Do you mean the $11 million refund?
The $11.7 refund, yes.
As far as I know, that's been paid. I don't have in front of me whether it's been paid out, but I would assume by this point it's been paid out. Because again, it was granted by the Board. The Board of Equalization heard the matter on their consent calendar and granted the claim for refund of the $11 million. The only issue was that the taxpayer continued to have was the offset of the $300,000. So, but the $11 million claim was handled and granted. So.
Okay, and I also have a question for the taxpayer, just so I'm understanding just the basis of the refund claim. So my understanding was that there was a $12 million refund claim. It was granted as to $11.7 million and disallowed with respect to $300,000 on the markup offset. Is that a correct statement?
This is Tim Gustafson. I believe that the the refund amount, the refund claim, that would be the software claim, effectively was granted in its entirety. But the payment amount was, that refund claim of 12 million, the payment amount was 11.7 million because of this affirmative audit adjustment to offset $300,000 off of the amount that at that time the department owed appellant. So the department owed appellant 12 million. The department asserted appellant owed it 300,000. And so when the notice of refund claim, it just netted those amounts off. So it's it just, as I'm describing it again, it took payment at that time of $300,000 when it only paid 11.7 million.
Okay, I understand what you're saying. Thank you. And so this amount has already been refunded to the taxpayer. Is that correct or not correct?
This is Tim Gustafson. That's correct, Your Honor.
Okay.
The $11.7 million.
Okay. And I'm going to briefly turn over to my panel members at this point to see if my panel members have any questions of the parties. Judge Aldrich, do you have any questions?
I have a brief question for City TFA. Under 6902.3, the enforcement proceedings, could you give an example of that typical kind of case?
The enforcement, so a typical one would be one where we file maybe a lien against somebody's property, and then we go maybe into their bank account and take money from them involuntarily. That's usually the typical 6902.3 involuntary payment situation.
Thank you. I'm going to turn it back over to Judge Quee.
Okay, thank you. This is Judge Quee. Judge Keith Long, do you have any questions for the parties at this time?
No questions. Thank you.
Okay, and I think this is Judge Quee. I think I just have one more question. So the notice that went out on January 27th, 2016, that was a notice of the board's action or on the refund claim. I'm just trying to understand the procedure here. If the taxpayer had disagreed with the decision by the board to offset the $300,000, I'm just trying to understand what the correct, in CDTFA's position, the correct procedure would have been at that point. Is CDTFA's position that a second claim for refund is the correct procedure, or was there a different procedure that just wasn't correctly communicated to the taxpayer? I'm trying to understand what that procedure should have been.
Well, I mean, the procedure that occurred here was that we informed them they had 6 months to file a claim for refund. They filed a claim for refund within 6 months. We believe it was a timely claim, and that's it, really.
Right. I guess I'm just not understanding, because you have, 6902 limitations period. The only way that it seems that you could fit, because you have 6 months from the date of payment that wasn't met, 3 years after the last day of the calendar month following the period for which the overpayment was made, that wasn't met. So it seems the only option is 6 months from the date of the determination becomes final. I don't see a determination here. I'm not understanding how that fits into 6902.
I mean, I think we would refer to you to make that decision.
Okay. And
we think this appeal should continue. That's our position. So.
Okay. Thank you.
Your Honor, this is Tim Gustafson. If I may comment on that your last question.
Yes, please do.
So thinking about it, in the decision and recommendation, that footnote, the department states that at least in that footnote, put forth that it should have said that there's 30 days to request an appeal or rehearing under regulation, Board of Equalization Regulation 5235, and that's governing action on refund. But again, the taxpayer had no action on its claim for refund. The claim for refund was granted, so there was never going to be any appeal on the claim for refund that was filed, the software claim. That regulation 5235 provides that. So, just thinking that simply that if a taxpayer, for example, if that regulation were to govern and the taxpayer didn't within 30 days file an appeal or request for a hearing, that regulation provides that the board would issue a notice of denial of a claim for refund. And so there was never any notice of denial issued. Because there was no denial. And going back to Revenue and Taxation Code 6933, the taxpayer had to file a refund on the markup issue in order to be able to pursue it. And so there has to be a mechanism for the taxpayer to be able to do that, because you had, again, a refund claim that was filed for a period of years. The CDTFA, the department, audited that claim. And during the course of the audit, and only during the course of the audit, they raised this affirmative issue, this markup issue. And then as we're, I think, characterizing it as an involuntary payment against that offset, functions as an involuntary payment against that refund that was granted. And in Regulation 5238, it talks about offsets applying against a array of amount offsets that were then due and payable. So as of January 26th, that deficiency on the markup was due and payable. And so they took that payment from the refund claim that was granted on the software claim. And there has to be a mechanism for appellant to file a claim, because again, even if appellant could have done appealed that or requested a hearing and on the markup issue at that time, if the board denied it, refused, if the board denied it or the department denied it, so let's say it would appeal either to the former Board of Equalization or here before your panel, and you denied it, then the taxpayer would be done, because under Revenue and Taxation Code Section 6933, any action in court is limited to the grounds for refund that are in the administrative claim. So there had to be the ability for the taxpayer to file an administrative claim for refund on this issue that was audited. And it makes under 6902 that 6-month window, whether it's from the notice of refund being a determination on the markup issue, or 6 months from overpayment, because again, once that refund of $11.7 million was paid, that was effectively appellant paying $300,000 at that time. You have the 6-month window to file the claim for refund. I guess another way to think about it is if that notice of action wasn't a determination, then the department never issued a determination, so we would still be within the time for the appellant to file a claim for refund.
Okay, this is Judge Kui. Thank you. I appreciate that, and that is helpful. Before we move on to closing statements, I would just like to make sure my panel is ready to proceed, ready to conclude the Issue 1 presentation. So, Judge Aldridge, do you have any further questions before we conclude?
No further questions.
Okay, thank you. And Judge Long, do you have any further questions before we proceed?
This is Judge Long. Yes, I do. I just want to clarify that both parties agree. I'm sorry, I'm muted.
You're not muted. We could hear you, Judge Long.
Okay. It appears to me that both parties agree that there was no hearing in front of the board and that the notice of refund was the determination that allowed CDTFA's Appeals Bureau to go forward with its decision and recommendation. Is that correct?
This is Tim Anderson. Appellant agrees that there was no hearing for the board on anything, not the software claim, certainly not the markup issue, which is current dependent of this appeal. And the reason that CDTFA, the department, is able to go ahead with and issue a DNR was because there was a timely refund claim filed within 6 months of the notice of refund, which then kicked off the separate second administrative process, which ultimately brings us here.
Okay, and CDTFA, do you agree with that?
This is Kevin Smith. We agree there was no hearing before the board. And we just want to reiterate, we think, this was timely and that you guys have jurisdiction to hear this. That's our position.
So this is Judge Quigg again. I mean, I guess in the context, not just, of how we would apply this type of case, the CDTFA is not taking a position on whether or not the appropriate time frame to respond should be or is under the law 6 months from the date of an offset, on the basis that the offset is essentially a determination from which would trigger additional 6 months to file the refund claim. Is CDTFA is not taking a position on that, or they are taking?
That's correct.
Okay.
That's correct. We are not taking a position on that.
Sorry, I'm just taking notes. With that said, I believe we're ready to move on to closing presentations. If the parties would like to make closing presentations, I'll turn it over first to appellant. You have 5 minutes to make any final arguments that you may wish to make.
This is Tim Gustafson. Thank you, Your Honor. Again, just to reiterate, we believe that there was a timely refund claim filed. CDTFA is positioned that there was a timely refund claim filed. There's no question that the procedure from the filing of that claim, bringing this matter to the Office of Tax Appeals, wasn't timely. Again, there was the DNR and then an appeal from that DNR. All of that is timely, and under the rules for tax appeals, the taxpayer has a certain period of time to appeal an adverse decision from the appeals division, which is what they did. Going back to that notice of refund, and again, remember, keeping in mind that the initial refund claim, the software claim, was granted in full. The markup was an affirmative adjustment, an audit adjustment. It was, again, looking in isolation, that was a deficiency assessment. That was an assessment against the appellant. And it's just an appellant paid the assessment in January 2016 in the form of an offset. It didn't pay, there was no assessment back when it filed the returns. There was no assessment in the years leading up to 2016. The assessment was at the audit that happened through 2015. That was the staff recommendation was approved by the board in January 2016, and a notice of refund was issued that said, here you go, appellant, here's your refund in full, but oh, by the way, we have to take payment on this new issue, this new deficiency assessment, $300,000. We are taking that now. In order for the taxpayer to make any claim, to argue that issue at all, and to be able to argue that issue at every stage in the process, there has to be a mechanism for it to file a claim for refund. And that's exactly what appellant did. It filed it within 6 months. If that notice of a refund is a determination, it was that the refund claim in July 20, 2016 was 6 months from that. That's also 6 months of overpayment. The overpayment was when CDTFA took that $300,000 in January 2016. And again, just looking at 6902.3 as a parallel, as an analogy, right? Those are the liens, levies, where there's an enforcement procedure. So the statute specifically says liens, levies, or other enforcement procedures. And that's basically what this offset is. The regulations provide that when there's a refund, and this is again 5238, when there is a refund that goes up, and before it gets paid, if there are any offsets due and payable, then you reduce that refund amount. That's exactly what happened here. There was something that the department said was due and payable, and so they took it. And if there is no mechanism for the taxpayer to file a claim for refund, then it cannot bring an action in court under 6933, because there was never any refund claim. That software claim did not have the markup issue listed in the grounds. And so I think it's clear under the statute 6902, and then we weigh in the equities on this, that the taxpayer had to file a new refund claim. in order to take this issue and be able to argue it throughout every single level, that that your panel should find that there is jurisdiction that it has. Again, CDTFA, as Mr. Smith has said, is of the position that it was a timely refund was filed and they treated it as timely. And so we feel that there's no question that your panel has jurisdiction to hear this. Thank you.
Okay, thank you. This is Judge Gui. I will turn it over to CDTFA at this point if they would like to make any closing remarks. Now is your final opportunity.
No, we don't have anything in closing.
Okay, thank you. We're ready to conclude the open portion of today's hearing. The balance of today's hearing and the appeal of T-Mobile is going to be held during a closed session. That means we're going to cut the live stream and we will resume at approximately 1:00 p.m. in the afternoon with the next scheduled hearing for the day. So I'm going to go off the record just for one moment while we cut the live